Good morning, everybody. We still have people joining us, but I just want to go ahead and get us going because we ran out of time yesterday, so we will try to pick up the pace so we can get to more of your questions. And so let me first introduce our team that will be on, handling all this. Jenna Tagawan is our tax attorney that's been focusing on this intently for a while and spends all her day reading court cases and contracts for SBIR companies. And Jenna, if you can say hi.
Hi, everyone. Thanks for joining today.
And then Jamie Bean is one of our CPAs. He's been knee-deep in this for literally years. And so he's going to help us by giving his perspective on everything. And Jamie, if you could say hi real quick, and then I will jump into the agenda.
Howdy.
Excellent. And so in today's webinar, what we want to do is go over the legislative news, the things we've done to try to change all this, the things that SBIR companies can do, and we will go through that quickly so we can get to how the new rules affect you, which is kind of your question, Gene. So what I'd like to do now is just quickly introduce Sycamore. We're an advisory tax consulting firm. We've been doing R&D tax credits for our clients for 12 years. We're here in Dublin, Ohio. And we've always been about, okay, what kind of substantiation is needed? So if the IRS ever asks ask about it, you're ready to defend it without having to do a bunch of extra work. So that way there are no surprises. I would encourage everybody to have their mic on, but if you have background noise, if you could mute that, that'd be great. So we're still getting people, but I'm going to go ahead because, again, we ran out of time last time. From the legislative news, there is a House bill and a Senate bill. And the House bill is as
Rick, we still got a lot of background noise. Can we make sure everyone gets their microphones off?
Okay. We'll give everybody a minute to do that. Excellent. So the House bill has 150 sponsors, and these are single issue bills on reverting 17174. You guys wouldn't have to do anything different in terms of your accounting or your taxes that you've always done. They need 70 sponsors in the House. The Senate version, they need about a dozen more sponsors. And we'll talk about things that you guys can do. We'll also share what we're doing on that. The things that we've been doing is we've been working with the Small Business Technology Council, that's Jerry Glover's organization, reaching out to Congress, also analyzing what these rules mean, how SBIR companies can navigate their way through them. We met with Capitol Hill folks in March, talked about a half dozen Senate and House offices, help them understand how this would affect you as SBIR companies. And they didn't quite understand it at the time, but I think we were able to educate enough of them that they could start seeing how this was really going to be hurtful for America's research and innovation. Jen and I are going to DC in early November to talk to folks about this. We're also going to be working with the SBTC group to see if we can organize basically what we call delegation events. When we were talking to Senator Cardin's office, they strongly encourage that. So we'll lean on the SBTC to help us organize that. And oops. We encourage other people to comment, and then we'll go over in a minute our deep legal analysis that hopefully provides you a little bit more clarity. These are the efforts that you guys can take, and we'll talk more about this. We'll send an email next week about how you can do this, but submit your comment to the IRS's open comment website, because they issued new rules. So far, there are very few people who put comments in there. If you can if enough of us put comments in there showing how devastating this would be, then the IRS may pull back these rules, and you guys can continue to expense things because you're just doing contract work, and you would be able to expense that. And you guys can participate in the this legislative delegation in DC. Plus, and the main thing we're going to talk about here today is how you can prepare in case these changes happen, not because everybody's got to file their 23 return, actually just in a matter of months. And as we know, the wheels of government move. Will take a little while to get going. And would like to let Jenna tell us a little bit about her perspective on this as a tax attorney and the things that she encourages our clients to do so that they're ready for it.
Hi, yeah. So I want to talk about the importance of, like Rick's saying, being prepared for the 2023 tax year. And what's crucial is starting to think about your approach now, because it is creeping up on us. So what I wanted to talk about is how many nuances that the IRS created with this new guidance. And this kind of gives us free rein to interpret these rules how we want, as long as they're reasonable, because they haven't been adjudicated. So all these arguments are fair. Essentially, what the IRS has done in respect to contract research is developed a rights and risk approach to assessing the implications of research services or developments of an SRE product, and how those risks and rights should determine how they're treated for capitalization purposes. So what's interesting is that they came up with a new term, financial risk. It's not the same meaning as they used in terms of credit purposes. They're using a concept of technological infeasibility. So the risk of financial loss has to be related to the failure of the research to produce the desired SRE product. So it's not the same purpose for funding, and it's not enough that you just suffer a financial loss. So we're trying to argue, you could just overrun costs. You could be building upon the same product for a new customer, maybe with a different variation. And so your company knows how to make that product. There's no real risk of product failure. You could just end up underbidding the project. And that's just a business risk. It's not a financial risk as defined by the IRS in these new guidance or in these new regulations. So what it comes down to is what's in the contract. The contract has to contemplate that the reason of that loss is related to potential failure of research in producing that actual product. So the three factors that need to be considered are your risks, your rights, but also what's in the contractual activity. I think that contractual activity in the language itself is very overlooked. We want to analyze each contract to see exactly what rights you have. SBIR companies do have rights by statute, but there are ways to minimize, or for some of you, we can even eliminate the amount that you might have to amortize, because some products just can't be commercialized to a public market. such as warfare or national defense projects that you might take on. So you might have the rights to it, but there's no realistic way for you to exploit those rights. We're kind of thinking of it as constructive rights. So we can use that argument for clients that, they might have rights in the contract, but it's just, there's no way to use them really, for the general public at least. Additionally, we're looking at arguments where you can say that you're out of the experimental phase and your project is actually in the implementation phase, and you might have eliminated the uncertainty and now you're just in the process of execution. So again, if this is a common product in your business, this could be considered know-how, which is not considered an SRE product under the proposed regulations. Or again, you've just eliminated the uncertainty and there's no real experimental phase. And the nice part about this is that the IRS has disallowed R&D tax credits to several taxpayers over the years by specifically arguing that they're past the experimental phase. So we're able to use those same arguments against them now so that we can minimize costs. So I just want to point out, these costs that are being paid is really an issue. And so looking at what the contract provides is really, really, really important. The contracts are going to state what are the risks associated, what are the rights that you have, what are you paying for, who's bearing financial risk. And so it's something that people need to examine carefully. And it's not a one-size-fits-all kind of situation. So as a result, documentation of how you made these determinations with respect to your company's specific facts and circumstances, and going into what were the implications associated with that is what's going to be key and what's going to help build your case and defend it to the IRS. So I will tell you from personal experience, going through each contract is really time consuming, and you definitely want to find someone to start working on that for you as soon as possible. I've been starting to review our clients' contracts now, and it's taken a while. So if you wait until January or February, it's just going to be way too late. You might miss things in the contract that could save you costs. So reviewing contracts is one thing, but you also have to factor in time for someone to prepare that written substantiation for you that builds your case. And so that you can turn that into
If folks could turn their microphone off if they have background noise. But we invite people to participate. So if it's quiet, we encourage you to have your mic on.
Thanks. Yeah, so I just want to point out that, you want to save time for people to review your contracts, but you also want to have time to prepare the written substantiation that you should turn in the same time you file. So all of the information that they need is right there. So basically, the biggest thing I want you to take away from this is to really start thinking to yourself, what can I do now? What steps can I take now to put myself in the best position for the next tax year, specifically if these regulations aren't going to change, which it doesn't look like it. So
there's a couple questions for you in the chat.
Hi, Laura. Thanks. I was going to introduce you, so thanks for doing that. I want to get Jamie and let him introduce himself. But before that, what are some of the questions you're talking about? Oh, you're on mute, unfortunately.
Rick, it looks like people are curious about the risk.
Yes.
The way we would, address this is, you have to determine if the financial risk comes from just generic business risk or technical feasibility risk. And that is the kind of crux of whether or not it's R&D. So the way we have been, discussing this with a lot of our clients, and someone said, is this just SBIR? No, it's also private sector. So we've been working with both private sector and SBIR. And we were working with a private sector tooling client who said, you know, we've never failed to make a custom tool in 50 years. We sometimes fail to do it in the budget we provide, but we've never had been confronted with a technological challenge that we couldn't work the uncertainty out of. And so their feeling is, you know, they're dealing with more business risk than technical feasibility. They feel that they can complete every single project. And obviously that's much different than SBIR. Their contracts are written differently. But you take the same approach. And Jenna and Rick can speak more to that.
And Jamie, if you could kind of use this moment to kind of share what you're doing for our clients to get ready for this tax season.
Yeah, so I've been in tax for a little while now, and unfortunately, the tendency of taxpayers is to kind of just push things to the back of mind, and kind of hope for the best. And so for instance, we've heard a lot of people say, well, we really need this change. Then we say, well, you're going to issue a public comment. They say, oh no, well, we're scared that they'll retaliate against us if we issue a public comment. And then we say, well, what are you going to take to your Congress people if you're not issuing a public comment, and they don't have any, hard data to point back to? And so it's just kind of this, cyclical, excuse cycle of like, well, we just hope it gets fixed, basically. And, I'm starting to get concerned because this reminds me a lot of the end of 2019. I was doing tax prep and financial services for small medical practices, dental practices, orthodontist practices, primarily in Ohio. And at the end of the year, there was talk that they might get shut down because, we had such dramatic need for the handful of masks in their offices, et cetera, so forth. And, all these doctors were like, that's crazy. No way would a health order result in, the population having less access to health services. And we were like, that makes sense, but a lot of times, the government does things that just don't make sense. And it's not until after the fact that the hammer has been dropped on some people that they realize, oh shoot, we messed up. And so what happened is, those health practices got shut down. And there were two groups of clients that we had. Clients that were like, I want to take this seriously. I want to be really proactive about getting my tax return done right at the end of 2019, closing the books, being ready to file. So based on what comes next, I'm ready to act, even though I think what's about to come next is absurd. In the same situation here, right, there is a lot of, overwhelming support for why this law should get overturned, or at the very least, why the IRS should offer a more cogent guidance that is more applicable to research and actually incentivizes research instead of disincentivizing it. But there's also just the unfortunate truth that it may end up like this, not only through 2023, but likely through the election year. So it gets back to, you want to be in that group of people that was prepared, right? Because my clients who had their tax returns done, when PPP got announced, they were ready to apply. When ERC got announced, they were ready to apply. If they had issues with staffing or if they were close to retirement and they just didn't want to deal with COVID, they just sold. And the same applies here. You need to understand, moving forward, what contracts are going to be just impossible to take if this law doesn't change. Moving forward, am I going to have to commercialize something, to be able to sustain cash flow to get us, to the finish line through when this law changes, or at the end of 5 years when the cash flow starts to cycle out. And so this is really important for you to approach proactively. Again, look at the contracts. So then you have things for public comment. You can go to the IRS and say, look, I'm going to have to stop working for the DoD if this guidance is not reversed, right? It's no longer profitable. I can't keep the lights on in my business. And that is, powerful testimony. But if you look at the IRS rules for public comment, it's not enough for you just to come say that. They want numbers. They want data. They want impact on headcount. They want to know what your effective tax rate is going to be. And so the only way to do that is to sit down, with your tax preparer or with an attorney and start having people go through and say, okay, well, this is what the taxes are going to look like. and then you can give that to the IRS. And if you want to do it anonymously, you can, and then you can give a non-anonymous version to your representative and say, look, here's my public comment with the IRS. Here's the fact pattern that matches. You guys need to take some action on this. And so that is, my biggest thing is a tax preparer. It's just, thinking of those clients who were kind of just caught off guard during the COVID, scrambling to get their PPP loans, scrambling to get their ERC loans, struggling to get out of the business if they wanted to get out. And so this is the things that, we want you guys considering here, in that, yeah, it makes a ton of sense that this law should either be reversed or the IRS should withdraw the guidance. But it also makes sense for us to be prepared for neither of those things to happen.
Guys, you're getting some questions. If you could just really briefly give an overview of Section 174, because some of our participants are a little unsure
Good.
what that is.
Thanks for bringing that up, because that's actually what we're going to try to sum up real quick right now to orientate everybody, which is Section 174 talks about the tax rules around research and development. You've always been able to deduct those expenses, and for those of you who wanted to claim R&D tax credits, you were able to do so. This new proposed rule change, would actually make it so that you can still get R&D tax credits, but you would have to amortize all your project expenses. And what does that mean? That means you would have to show phantom income, which is income on paper, but not in the bank. What's an example of that? So if you had $1 million of expenses, and this is all deemed research, then you would have to show that basically you can only record 100,000 of expenses, and the rest would be income for that year. Now, you might be saying, hey, we're SBIR companies, all we do is research. So does this mean we have to amortize everything? Up until earlier this month, the answer was no, because you were doing research under contract, which means it's just cost of goods sold or an ordinary necessary business expense. And that has always been allowable under the regulations, that you can deduct it. And it's always been allowable that even though you deduct it as cost of goods sold or just a regular ordinary necessary business expense, that you could get R&D tax credits. These new proposed rules would still let R&D tax credits, but it would force you to have to amortize those underlying expenses. So if someone has $1 million of expenses, they would likely be eligible for 100,000 in credits, which sounds great, except if you add 900,000 of income to the return, for most people, that's going to be 300,000 or 400,000 of taxes. So you don't want the 100,000 in credits. Now, what's the good news in this, if there is good news? If the rules don't change, we have studied these new rules, and it basically will mean, because they change the definition so much, and we'll talk about that in a second, that even though your contract says research, that contract itself may not be deemed what we call a 174 contract. And if it were, you would have to amortize some of those costs. But we've also, over the years, learned what Jenna was talking about, which is just because your contract is deemed a 174 contract, doesn't equate to all the expenses having to be amortized. As the example that was brought up, if your design, like in SBIR 1, during that phase, but then your just build is in the second phase, then it's reasonable, and the IRS has argued this for years, that the only R&D you had was in phase 1 because you had already figured out the technological and feasibility question. And for the build stage, you would not have to amortize. Now, you would also not get R&D tax credits, but in this moment, if the rules don't change, you're okay with that, because the alternative is really not livable.
I want to respond to a question here. It says, the point of section 174 is that money you have received from the government for specified research and experimental nature cannot be taken as a deduction on your tax return. Now it has to be amortized. What we're talking about here is starting to parse out, based on the new rules, what actually does have to be amortized. I wouldn't, based on the old rules, pull everything that was being treated as 174 into the new 174. Right? So part of this is about understanding that when they introduced this concept of specified research expense, they changed the definition of what these expenditures are. And so you don't necessarily have to amortize as much as you're thinking right now. And so, I would hang on and try to, stick with us here. But, what we're talking about is, applying the law in earnest, looking in detail at what it's saying and saying, well, it's actually way more specific than 174 used to be. So it doesn't make sense that everything used to be in 174 would still be in 174. So that what we're saying is, it's not as bad as it sounds. It's because they have narrowed down that definition. So I would, push back and say that now it has to be amortized. Some of it will, but a lot of it will be through documentation and through a close following of the law be, kept in cost of goods sold and deductions.
Excellent. Laura, you said there's some other questions?
I just wanted to point out there's a couple questions about the word contract. I responded to one, but basically what we're doing is we're looking at your SBIR grant, but each grant is subject to different terms and conditions that we're reviewing, as well as which government agency is granting you those funds, because they have different policies, as well as the federal statutes that we have to review.
And Jenna, have you looked at any NSF Phase 2 grants yet?
Not yet.
Bummer.
We've looked at like NIH Phase 2, but
Yeah,
other ones, but not NSF.
I'm seeing a couple of questions come in about timing, as far as, does this apply to the 2023 or 2022 year? So the congressional law applies to the 2022 year. Now for 2022, that law had no IRS guidance. So what you do in that situation is you have to just apply a good faith application of the law based on the existing guidance and historical treatment of R&D. And so we would say, don't apply these new rules to 2022. We would say, look at the congressional law, make a good faith interpretation of what that means and apply that to your code. So what we're telling people is, your internal research and development, we would say that probably would be amortized. But things you're doing on contract, your research for hire, we would continue to do cost of goods sold, continue to do deductions.
And when you say continue, Jamie, you're talking about 22?
Talking about 22. And then 23 is when we will fully apply the rules. Now, you may have read through the notice from the IRS, and they do say that you can apply the 23 rules to 22. You hadn't filed your return. I don't know why you'd want to do that, and it is an option.
I have a question.
Go ahead.
Can I ask a question about the, someone mentioned know-how versus, I guess, patented IP? So is there a difference between those now?
Jamie or Jenna, would you like to answer that question? Otherwise, I can take it. In short, the new proposed rules say that know-how no longer equates to a Section 174 expense. And they're very specific about that. That was never been said before, so that is new. The other piece of that, though, is they've just redefined that what's a 174 expense. But most importantly, to answer your question, it's the if you have the patent, that is spelled out in the new guidance that says if you've applied for or have protection under a government for rights in what you're doing, that by itself would trigger the expenses of the contract being deemed a Section 174. But it's actually a little bit more complex than that. And that is because you may get rights in it, and you go, we apply for a patent, so I guess we have to just amortize everything. And we say, okay, you're right that these contracts are deemed what we call 174 contracts, but not all the expenses. And that's back to the, okay, I had a phase 1 and a phase 2, and then I patented all this stuff, and now I got something. Then the patent cost, the IP, the IRS has always wanted to argue that happened in phase 1. So yes, everything you're doing leads to having rights because you apply for a patent, but it won't be all your expenses.
Okay, thanks. And so that's a slightly different argument to going through the contract, going through the project and saying this phase, okay, so we're in phase 2, this beginning bit we'll call R&D, and then the next bits we will argue it's not R&D for these purposes. What you're saying is the whole thing might be argued in phase 2 as being not 174.
That is correct, but it's facts and circumstances dependent. Because sometimes for contractual reasons, you'll go, well, it's a phase 2, but they asked us to do some additional design work at the beginning of that phase. And just contractually, the contract office said, do it this way and we can get this approved. And so you do. So it really boils down to actually examining the activities that occurred. And can't stress enough that it's actually just writing your understanding of the events and the application of the law. And that's going to get you 95% of the way to where you need to be. Because if the IRS comes knocking, you can say, hey, this is what we were thinking at the time. This is how we made this delineation between what's the design phase and what's a point where we go, okay, there's no more technological infeasibility. We're just hoping we can do this build out under budget.
Yeah, and I guess we're getting a little behind on questions here. I'm seeing questions, do salaries need amortized? Do indirect costs need amortized? And the answer is, yeah, the IRS went just ruthless in this. I mean, and for indirect costs, they say, that they are employing a cause and effect method. And then as you read through the method they describe, you realize it has nothing to do with cause and effect. They're just apportioning all of your indirect costs to R&D based on how much R&D you did. And so, again, that's why it's important to be able to break down the projects and say, well, this stuff wasn't actually R&D. Because if you come in with a huge direct cost R&D number, it's going to pull in most of your indirect costs into that R&D amortization as well. And so again, it is, the IRS wrote a comprehensive law to pull in nearly every expense of researchers into amortization. So the way to navigate it is to clearly identify what is and isn't research. And in regards to subcontractors, yeah, that is an issue that they totally failed to address when it appears like rights kind of belong to both. And we're actually working on a public comment with another CPA who is, pretty upset over this, this idea that, basically every party in a transaction is going to be amortizing all their costs. It, would quickly just nuke our research industry.
Exactly. And that I do want to use that moment to mention that we were publishing an open comment to the IRS. I'm trying to get it done this week. And it'll be our legal analysis. And we're hoping when we share that with the IRS that they'll incorporate those ideas, not ideas, but the things that we learned in our analysis. And basically what we learned is that there's never been an intention for Section 174 or Section 41, where you get the credits, to say that you have to record everything under 174. fact, section 41 for the credits is specifically written to say, if you have expenses that would qualify under section 174, which is simply saying that they're research and experimental expenses, then you get all the benefits of section 41. Well, where you're reporting those expenses, you're doing research for hire, it's just cost of goods sold. It's no different than you're just a commercial engineering firm. So you can both get the credits and record those expenses under cost of goods sold or just ordinary necessary business, like you've always done. Because of that, well, that's what we want the IRS to recognize, because if so, it would help you guys, but also would help anybody doing engineering for hire. And so that captures a wide swath of our innovation ecosystem, because as our economy's gotten more specialized, organizations have pushed research into organizations like yours. So you're doing research for hire, but that's actually where all the innovation is happening. And the IRS, the Congress is always one to incentivize that kind of activity. Hey, Laura, are there any questions?
Yeah, Jamie, there's a question from an accountant about how you would track these.
You would capitalize your section 174 R&D asset and then amortize over 4 years. The IRS put out earlier guidance on like what that account should be named, you know, and so forth. But basically you're creating a new asset that is just all your expenses for research and experimentation, which you'll now be amortizing over 5 years. So
yeah, it gets a little when we talk to other CPAs and other tax attorneys that are focusing on this issue.
And in regards to tax first book, it is whoever CPA said, you know, this infects the tax return, but not your financials. There's actually a lot of questions over that, because your tax return and your actual cash flow would be so far removed from what a traditional, you know, GAAP financial statement would look like, that there actually are a lot of people asking questions of, you know, should you actually display this asset on your financial statements also, right? Because someone looking at your financial statements versus someone looking at your tax return will get a really different answer based on how you are tracking this in both.
I have a question. So as NSF Phase 2 SBIR, the funding structure, which is pretty common, is 25% upfront and then 3 other 25% allocations based on 6 monthly reports. Okay. So could it be argued that that first 25% is no financial risk, and that would not be applied to 174?
Well,
Yes. So I was looking at the NIH grant policy, and none of the language specifically ties to the failure of your product. So it's really just procedural risk if you don't comply with those payments, and they're really just milestones. And there's also a case that I was looking at where the research wasn't funded when the taxpayer received progress payments. So I want to look more into that one to build a better argument for our client, but so far, no financial risk.
Yeah, and but to be more specific, in this case, it's a very common structure in the Phase 2 that a quarter of the payment is made available on day 1, right? There's no reporting, etc. Yeah. And then the next quarter is available, so let's say 6 months later. And so my question is that first quarter not applied to 174 because there's no financial risk
I like
Do
that.
you know what I'm saying? I'm not talking about the whole thing. I'm talking about a quarter of the thing.
Yeah, that's a fact and circumstances specific thing, Richard. And we should reach out to me and we can schedule some time to go through the specifics, because it does matter what the activities are and the wording of the contract. In fact, actually, I would like to invite everybody, because we're probably not going to get to everybody's questions. We're certainly not going to have a chance to talk about each person's specific situation, to please email myself or Jenna or Jamie. I think Laura, if she hasn't already put it in the chat, she will put our email addresses in the chat, because we'd like to be able to give everybody time to be able to talk about their situation, because they actually are all a little bit different. You're very similar, but you're different in ways that could make it so that some of you have like no amortization cost, and others of you, fortunately, with our understanding of it, would have low cost, not enough to steal you of all your cash, enough to make it so you wish the law would change back, but not enough that you can't keep doing what you're doing.
Yeah,
One
thanks.
thing that
Understood.
one thing that does apply to everyone though is the indirect cost. I'm seeing some questions of, oh, well, these are just costs to run the business. And we agree, but unfortunately the IRS doesn't. So they're going to say, if you have a 20,000 square foot facility and you do research in 10,000 square feet of it, 50% of your rent needs to be amortized. And they're going to say, well, if you have a legal team and they spend 15% of their time applying for patents, 15% of their salaries is going to need to be amortized. And the list goes on, right? Utilities. Well, if 50% of your facility is doing R&D, then 50% of your utilities need amortized. And they say, they have opened it up so that they can apply basically any allocation method they want to any expense they want to pull in. And so again, it gets back to, that's why you want to be telling them, well, these expenses had nothing to do with R&D, so I don't know why you are trying to amortize them, because otherwise they're going to go in and say, well, you were doing R&D, and I'm just going to start allocating indirect costs to that, even though it's just like you guys said, it's the cost to keep the lights on, it's the cost to run the business, it's cost you would have whether you were doing R&D or not. It's just the way the IRS is going to approach this issue.
Very true, and that's why the key thing I want people to understand is that this is brand new. And Jenna was saying that there's a lot of everything is fair. Another way to say that is reasonable positions are available to everybody, because this is not settled. The IRS is still figuring out how to apply these laws. We all are. So in a few years, it'll coalesce around some things where we all have certainty on how to do this. Right now, we do not. So if the IRS ever asks you about this and you just provide an oral argument, you're probably going to lose. However, if you have a written argument that's written at the time that you filed, that explains, as Richard was saying, what part is design and what part is no longer design, or where do I have financial risk and where do I not have financial risk? If you have that in writing, then that pretty much gets you 95% of the way there, because IRS agents don't want to put folks out of business. Because they're actually good folks. They're our neighbors, the actual rank and file. They are really hoping that you guys have your ducks in a row, because then they can say, okay, good, let's close this case and move on to somebody who is just trying to commit fraud or just being really, really sloppy and not paying due attention to this. Hey, Laura. Oh, go ahead, Jimmy. Sorry.
In response to some people saying it seems like this law is basically the exact opposite of what 174 was intended for, and is, basically defying the spirit of the SBIR program and, research incentivization in general. You're absolutely right. 174 was written for the purpose of increasing research and development. It was written to help startups get the same treatment that, large conglomerates with big R&D houses already had. And it was never intended to capture these, research for hire companies that have, research as their cost of goods sold. So the interpretation the IRS has put forward, you guys are correct. It's absolutely just thrown everything on its head. The good news is there's public comment. We can, and that is a valid public comment to point out that, hey, you're overstepping your authority here. You've reversed the congressional intent of the law. And in doing so, you basically wrote a new law, right? You disincentivized R&D, and now you're punishing researchers. And the good news is that the TCJA is already going before the Supreme Court for another one of its tax provisions for also overstepping constitutional bounds. So this is a valid argument, and I would encourage everyone to submit public comments or to, that's gonna be part of our public comment. And if you want to jump onto that and share that with your representatives and so forth, it's a very compelling argument. And there have been a handful of Supreme Court and tax cases that have, led a lot of people to believe that, if anything, if the government, remains stagnant on this, if the IRS holds its ground and doesn't withdraw guidance, that, it should get overturned. But I would go one step further and say you should go to the public comment and say that you think it's unconstitutional, that for these reasons, that it's reversed the purpose of 174, that it's made the Section 41 R&D credit useless to everyone, and that it is killing this SBIR carve out, which we have put so much work into building and fostering over the years, specifically because the research is so important. And so that is a really valid defense, in addition to giving the IRS and your representatives the the financial facts of how this is going to impact you.
Excellent. That reminds me that what we'll do is next week or the week after, we can send out an article that we published in Bloomberg last year that spoke specifically of what the historical intent of Section 174 is. It's a good background read for your open comments, because it elaborates on what Jamie just said, is that the intention of the law was to spur innovation by letting startups deduct expenses or report expenses in their tax return, because before 1954 they couldn't, only established businesses. And so the article talks about that, and that will inform your critique of what the IRS has done, because you can say, because they basically have made a different assertion on congressional intent. They completely ignored that it was about making so startups have a way to, they're incentive to do R&D because they could actually start recording those costs in their tax return. Instead, what the IRS started this 45-page document with when they came out last month was they asserted that the congressional intent of Section 174 was to separate what is research and experimentation and what is an ordinary necessary business expense. So my dad had an engineering company back then, and he was always doing things that met the definition of research and experimentation because he's an engineer. But he was always able to record his expenses as ordinary necessary business expenses because it was all under contract for a customer. And that fact didn't change with Section 174. It did not disturb how people were doing it. And subsequent laws like Section 41 were written consistent with that idea. And so basically what you want to be able, I would encourage everybody to mention is, hey, I've always been able to, I'm just doing research for hire. And I've always been able to record my research expenses as ordinary necessary business expenses. This new, under your new proposed rules, IRS actually undoes everything that we just talked about.
Yeah, I think probably the most egregious part of this is the IRS, as their reasoning for this interpretation, they cited a court case, a Supreme Court case that they lost by unanimous decision for their last incorrect interpretation of 174. And so it's just, I mean,
Which was that
it's
same
not funny because it's very real for all of us, but it is, it kind of blows your mind a little bit.
Well, because also to add to that, the thing that the Supreme Court said no to was the very assertion that the IRS made back last month, and the assertion is, so the IRS was asked about what's the purpose of this, and in that court case, and they thought it was about separating ordinary necessary business expenses from R&E expenses. And the court sided with the other side saying it was about startups. What we're going to do is post comments on it to help the IRS recognize that, because we're optimistic that when they do, they'll pull the rules back and modify them so that anybody doing research for hire will both be able to get R&D tax credits, but would not be forced to amortize those expenses. So I think if we all chime in on that, that will give the IRS cover to go, oh yeah, we want to address that, and we'll pull the rules back and we've modified them accordingly.
Rick, we have about 5 minutes left.
Okay. So what I encourage, we'll get through a couple more questions, but we have a hard stop at 11. And so I would encourage all of you guys to email Jenna or Jamie or myself. And we're happy to set up one-on-one Zoom calls so that we can quickly go over your specific situation or in your question. Laura, is there another question that you think we can
There's
address?
actually one kind of important one I just saw pop in, knowing which members of the House Senate are currently in favor. So a lot of them, basically everyone in the House and Senate will tell you they're in favor of it. The question you want to be asking and checking for is who's in favor of a single issue solution to it. So right now there are 58 progressives in the House who are basically holding you guys hostage to push forward a handful of their agenda pieces. And they're saying, the Republicans blew it when they wrote this law. In our opinion, the IRS is the one that blew it. The law is actually not that impactful, but they're going to leverage the situation you're in. So those are the people you want to be reaching out the most. Is Primula Jayapal is the head of that bill. I'm trying to find the number for it, but they're the people you want to be reaching out to say, hey, I'm not a bargaining chip. My business, my livelihood, they need to come first before your political agenda. There's a single issue bill in the House and a single issue bill in the Senate. Both are getting close to the number they need, but you need these senators and representatives on the progressive side to stop holding it hostage. They have enough votes to keep it from passing, and that's the
yeah. And so we want to attack this. Address this on two fronts. One is by reaching out to our representatives about the impact, but also reaching out to the IRS about helping them understand the impact that it would be to research and to, like, how many people would you be looking at having to lay people off? And the other thing you can do is kind of what we're advocating, and what we will do is just say, hey, this looks like to us completely reversing the intent of 174. And we would like you to reconsider these rules based on that, in light of that.
Yeah, we were talking about this yesterday, and at the end of the day, these IRS people, they're just doing the best job they can, but none of them want to be on the team who issued the guidance that, collapsed America's R&D, sector.
Yeah, so we got to help them out by letting them know here are the deficiencies in it, and they will be very happy to get it in the end, because it'll mean they can avoid what you're doing. Hey, Laura, is there another question that we can squeeze in?
I think folks are mostly wondering how they can get in touch, and or if we don't get to other questions.
If they could email, so Laura, did you put our email addresses in the chat?
Yeah, it's up a couple times. Yeah.
Okay, good. So yeah, so it's my email is in there. Actually, the email that you got for this webinar has my contact information, and you can reply to that email. I would encourage you to reach out directly to Jenna and Jamie, as these are the people that I lean on when trying to understand all these issues. Excellent. And so we have just a couple minutes and we'll need to sign off. What we will be doing is sending out an email next week with some bullet points on things that you can say in your open comment period. We will also, so for people who do not want to list their name or their company's name in their open comment, then we're looking at trying to send out like a survey to everybody where they can submit it to us, and then we can combine them all into one large document and submit that in the open comment section. Senator Cardin's office was encouraging that if you do that, to then do what Jamie was saying, which is send an unanonymous copy of that letter to your representative. And the things that Cardin's office really asked was, hey, show how this is going to be really hurtful to your business and to people's jobs and things like that. Jamie?
Rick, there's one thing I want to address. Someone said, to pay a CPA firm would mean, no more internships. We have been working with people who work with the grant applications, and they're very confident that, any additional CPA costs that they incur, and Rick, you can probably speak more to this about.
That's a good point. Yeah. So what they actually brought up to us is like, hey, Rick, you got to keep in mind that all accounting costs can be added to indirect costs. And you're going to have to spend much more on accounting to make it through this change in these issues. But the good news is at least you can add that to indirect cost. So you're passing along the cost to the federal government, which is a little ironic because the Treasury is trying to get more taxes from you, but unfortunately it's going to mean higher research costs for the federal government. So I'm glad you brought that up, Jamie, because I know people don't have a whole lot of extra money. At least when they get it reimbursed down the road, then that makes it manageable.
4 more minutes take us to 11.
Okay, great. Again, we'll be sending out an email next week with, we'll probably send out the Bloomberg article to give you a nice history of it. We will be working on that survey. We're working on just an email where we'll give you the link to the public comment plus some bullet points. Many people have asked, hey, can you give me a template to use? We're concerned that the IRS would see that as a form letter and then just delete any of them that use that template. That's why we will provide bullet points, and you don't have to spend a lot of time on it. Just kind of list the ways it's going to affect you, how, like maybe if you have to say no to doing some more research, to taking more research contracts, maybe if you have to delay hiring, maybe if you have to furlough people for a while. All the ways it's going to impact you and impact the ability of you to be able to do the research that's sorely needed. I want to thank everybody for joining us. This has been an enjoyable call because we've been able to answer a lot of questions. We hope this has sparked you guys to want to spend a little bit more time on this to make sure your situation is going to be manageable if nothing changes. And I would invite you guys to reach out to us and we'll have one-on-one conversations so that we can help you understand exactly how this is going to affect your situation. Well, thanks, everybody. We appreciate it.